Good morning everyone. My name is Santosh Kumar Behera. I'm working professional in Utkal University. I'm a research scholar in law. Uh, my research topic is about need for changing paradigm in disciplinary proceeding in industrial enterprises for better participation of the employee. A study on socio-legal perspective. Now, one of the most important factors for ensuring every workplace, whether it is a public sector company or a private owned industry, to run smoothly and for production of a high output, maintenance of discipline is utmost essential, and every person who are employee of the particular company, they must follow the rules, regulation, norms in a disciplined manner. Now, industrial discipline, in the context when we say about the industrial discipline, it is an orderly performance of an industrial undertaking workforce in accordance with the predetermined rules, regulations and norms. The disciplinary process is a process that the Indian labor laws have established to address the issues connected to the employees' violations of norms termed as a commission of misconduct. But even though the provision of relevant laws have been created for it, there are no clear rules till now in Indian laws which created the employers the want to initiate a disciplinary action on their whims, and sometimes it leads to manipulation of the workforce and engage in victimisation and unfair labor practices. Indian labor laws containing disciplinary measures are not free from flaws. My objective is to highlight those aspects, socio-legal challenges, with the recommendations to overcome the obstacles in maintaining the better working capital. Now, industrial discipline, I already said that it is an orderly performance of an industrial undertaking workforce in accordance with the predetermined rules, regulation and norms. The discipline which indicates the regimentation of the thinking and behavior found in the military. Discipline unquestionably the antithesis of disorder, irregularity or confusion of human behavior and conduct. Any effective activity requires discipline, and when it comes to industrial discipline, it's important is that it should be organizational discipline is the essential in industrial settings. A crucial component of an industrial unit performance is the presence of perfect peace, harmony as opposed to disorder. Now, there are several categories we can find out in discipline. Any effective activity requires discipline, and when it comes to industrial discipline, its importance is amplified. Organizational discipline is the essential in industrial settings. A crucial component of an industrial unit performance is the presence of perfect peace and harmony as opposed to disorder. In a climate of discipline, the working environment gets better, labor productivity rises, output picks up, and the organization as a whole prosper and meets its objectives. Self-imposed and enforced discipline are both acceptable. Till now, when discipline is self-imposed, employees control their own behavior, but when discipline is enforced through control comes from the above, then discipline, we can say it is enforced discipline. When the discipline is self-imposed, employees will naturally work spontaneously. No enforcement is required because the internal incentive is there, but the workers have stronger incentive to put additional hours. However, there are times when the managers requires to use the coercive measures to get obstructive workers to cooperate. Now, two forms of industrial discipline exist now: optimistic and adverse. Although there is no set of strict process of disciplining the employees, the steps in the process are as follows: sending the letter, charge sheet that includes accusation or of misbehavior or indiscipline or request of explanation. When the letter charged is unanswered, consideration is given to the explanations. The so-called notice, the management issues a notice. There is enough prima facie proof that the employee's behavior in their opinion. When enough misconduct is found, notice of inquiry is issued. This notification, when includes the name, inquiry officer, the time, date, location of the inquiry, is served. Then another is that conducting an investigation. This is in accordance with the natural justice principle. Since the employee must be given the chance to be heard, the inquiry officer advises the type of disciplinary actions to be taken when the investigation is complete, and the results are documented. The employee's prior record present the circumstances must be there. So disciplinary action on the other employees etc. must be taken into consideration, choosing the types of penalties. Now, filing an appeal also is there in these disciplinary actions. If any person is dissatisfied by the decision of the inquiry officer, he can go for an appeal to the higher form, like labor courts or like tribunals. The employee is given the opportunity to appeal when he believes that the inquiry or the investigation is not properly performed, improperly performed, and the action taken was not warranted. Follow up. Now, after implementing the disciplinary measures, the correct follow-up measures must be implemented. Now, why this industrial discipline? When we talk about the industrial discipline, there are several reasons why a person will be indisciplined. Now, the factors are several. But the first thing is that where there is unfair disciplinary actions taken by the management team, when there are several persons who are the head of the department, they have taken any unfair disciplinary actions, it also causes one of the indiscipline among the employees. Now, postponing, ignoring the resolution of the employees' complaint, favoritism and nepotism in hiring and promotion decisions, and the management staff's tendencies to be overbearing is excessive. A communication vacuum exists between the management and the regular employees. Insufficient oversight at the operational level, and information gathering through the use of secret police methods. Now, union leaders provoking behavior, personal hostility, envy, divide and rule philosophy. So, these are some of the instances which I have mentioned here. Try to cover those that where a particular person has not behave as a disciplined employee. Now, the reason for indiscipline that we listed above may come with the workers themselves, but the management is mostly to blame. Indiscipline can be have a variety of causes, but occasionally it is extremely significant repercussions. Absence of common objectives or lack of conducive relations between the employee and the employer. It is futile to expect a better disciplined working people and more economic output if these are detrimental to the employee's right and dignity. Now, till now, Indian Labour Conference in 15th Labour Law Commission has it was conference held in 1957. It has been addressed that the issue of workplace discipline it is utmost essential, and there are certain guidelines has been provided that if the employees have any complaint, they must it must be solved, it must be settled voluntary arbitration, conciliation and mutual bargaining. And since June 1958, the Code of Discipline has taken effect. The following guidelines were spoken out that there should not be unauthorized lockouts and strikes. No action should be done by itself. No use of go-so strike, no willful harm to a plant or piece of property. No act of violence or compulsions, intimidations, incitement. The dispute resolution tools already in place should be used. Award and agreement should be executed as soon as possible. No arrangement that undermines the friendly industrial relation should be made. Now, these ideas, these recommendations, which have been fully embraced and included in the Code of Discipline. A Code of Discipline was created by codifying them with a few adjustments. The Employees Federation India, the All India Organization of Industrial Employees, and the All India Manufacturer Organizations approved on this behalf of the employees, and the four primarily national labor organizations, that is INTUC, UTUC and AITUC and HMS, on behalf of the workers. However, the Code of Discipline was unable to stop the big strikes that took place at the Jamshedpur steel plant and Hindustan shipyard, heavy electrical, Bhopal and dockyard, significant ports. In 1965, there was a session on how the Code of Discipline operates. Again, in 1967, the Central Implementation and Evaluations Committee met and assessed the operation of the Code of Discipline, and the proposal to establish a National Arbitration Promotional Board to promote the voluntary arbitration was finalized. Now, what is industrial discipline and how it is to be maintained? The upkeep of the workforce discipline is a challenging and very involved activity that requires a very efficient handling. There are several methods to adopt, but some of them I have given here. When establishing the laws and regulations, worker must be consulted. many of the time it seems that with the rules and regulations, they are, though it is been for the workers, but they have never been consulted, right? What is the good for them, what is the bad for them? They have no opinion about the rules and regulations. So it obviously cause dissatisfaction of the employee if they have not been consulted. Now, rules and regulations need to be written clearly. There should not be a chasm in the lines of communication between the management and employee. The new employees need to be get through the orientation. Thorough the orientation program is utmost essential for this, because that is the way that the workers will be trained. To help the employees comprehend them, and charts, graphs, and other approaches should be employed as needed. Only utilizing the penalties for breaching the law when it is really necessary, but where there is no essential to inflict the penalty, the employer should not be other to such type of method. Now, punishment should not be intended to create the victims. Casteism, nepotism, and favoritism ought to be avoided. Managerial members should be never breach the laws they have set up to enforce the discipline. Discipline or a code of behavior should be established and observed. Establishing the disciplinary commission is necessary. The right machinery needs to be put up to hear the appeals of the injured party. Now, the methods for sustaining the discipline have been covered in general above. There must be some steps to address all these issues. Now, the two basic principles are there, which is adulterum partem and nemo juris causa, which must be followed while any disciplinary action is to be taken against any employee. But if you see that the procedure which has been adhered by the disciplinary committee, like initial investigation, the cordial discussion, verbal warning, or initial official warning, infliction of the penalties, layoff, like all these, we all know that as clinical approach. But in India, when this in discipline it is to be handled, the principle of natural justice principle are not in the strict sense, it is not followed. Why? Because sometimes the employer is not permitting the employee to give his defense, and sometimes the employer himself is in a position where he has been he has more to blame. So in that case, the employer cannot decide, or he cannot appoint an inquiry officer, because it will obviously make the sense that the employee will watch the inquiry officer, and he can he can be a party where the employee will have to suffer, and he has all control over the inquiry or domestic inquiry. Now, disciplinary inquiry. Now, what are the essentials of the fair inquiry? First thing, I already said that there must be fair opportunity must be provided to the employee to to provide his defense. That is, and whatever the charge sheet has been given to the employee, that must be known to the, that must be communicated to the employee, and a copy should be handed over to the employee. But most of you see the disciplinary action which has been taken till now in India, where the employees are aggrieved by all these irregularities of the employers, where they have taken any disciplinary action against them. The Honorable Supreme Court has given guidelines for that the procedure for the conducting of inquiry of industrial adjudications, and it has been held that the inquiry cannot be said to have been properly held unless the workman proceeded against must be informed clearly what the charge has been levelled against him. The witness must be examined in the presence of the workman. The workman must be given a fair opportunity to cross-examine the witness, including himself, and if he wishes so. Now, punishment, the last part, when the inquiry is completed and the employer want to punish the employee for any misconduct, if it has been proved, management should be based its decision on the severity of the wrongdoings, the investigation findings, the worker's prior performance, and the other relevant factors must be taken into consideration. The worker must be get a written notice of the sanction as soon as practical. The letter of communication should include a notice of charge sheet, the investigation, the result, and the date when the sentence will be take effect. Now, my observation here, which I have made, the the doctrinal approach that domestic inquiry in a disciplinary process is a fact-finding procedure important for maintaining the industrial relations with which ensures a smooth functioning industry with high productivity. There is a lot of prejudice because there is no predetermined guidelines still now for assignment of punishment or inflicting the punishments. A step towards the maintaining the principle of natural justice would be standardize the penalties for the misconduct, which must be adequately specified. In order to give the employee a fair opportunity to be heard, a representation might be chosen from among them, and there could be also be an arbitrator who would be given the power, the procedure for disciplinary authority to give the decision of inquiry. Although the employee is entitled to specific amount of pay during the suspension, frequently the employee does not receive that amount which he should get. To make sure the worker receive their pay, it is the duty of the union representatives to be vigilant of that particular matter. Administrative tribunal also must be created or is to be established to allow the employee to use his right to appeal, and if he is unhappy with the investigation process, the penalty should be which has been inflicted of him, then it should be resolved without any delay. It should be in the urgent manner. Now, in my conclusion, I have arrived which that though we in India have several laws like Standing Order Act, like Officers Regulation Act, CCA rules, but the benefit of all these statutes are going not for any particular person, not for the neither for the employee nor for the employer, because employee here also not in a position to understand that what step is illegal, because there is no specific laws which direct him that he should adhere to this type of procedure while he is making any disciplinary action against the employee. So that is the prime concern for the legislature, to enact a particular law which equally gives the direction to the employee and the employer that the the code of standards should be maintained, and the employer who might using his false claims of wrongdoing, the penalizing the workers out of the enmity, he may also abstain from doing such things, because it will also obviously it will be create a hindrance for the employers to take all these steps against any employee because of his enmity. Now the adjudication process must be also be delayed by the employer. This is also a crucial point, because where there is a lacuna of or loopholes in the laws, it would not create a term bound approach to start or initiate the disciplinary action and to complete in a particular period of time. So the major goals of domestic inquiry or investigation is to uphold the workforce ethics, to promote the harmony within the workforce between the employees and employers, as well as amongst the workers. Now, domestic inquiry with the aid of the set of rules outlined in a standing order would likewise work wonders by alerting the function of ADR, alternative dispute resolutions, and it will ease the burden of the courts, obviously, in the way the majority of minor complaints can be resolved through these alternative dispute resolution methods. So this is my observations, and for your kind friends, I have given here some of the references. Thank you.